Hello, everyone. My name is Ariella. Excuse me. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions, a national construction document service. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have the expert and the fabulous Bryan Thomas today, who will be discussing on part 6 of 10, Overzealous and Improper Liens in Tennessee. So without further ado, I introduce the fabulous Bryan Thomas.
Well, thank you, Ariella. Much appreciated, probably more than is deserved there. But anyway, welcome everyone this morning again. We are going through the Tennessee lien law, and today we reach the topic of overzealous and improper liens. For those of you who haven't been here, we've got a slide up on the screen. Reminds you how to use this GoToWebinar. If you got any questions, feel free to raise your hand or send them along. Ariel will pass them to me as we go, or we can answer at the end of the webinar today. Now, it is a multi-part series. If you want to tune in to some of the ones in the past, I believe Ariel has got them posted on our website. If you want to tune into any in the future, please join us as we go forward over the next 4 or 5 months. Now, we're going to start again where we have been over the past 5 months. Tennessee basics. Who has lien rights? Prime contractors and remote contractors for work for actual improvements made on real estate. And it's to secure essentially the contract price, which can include extras. So that's where we are at a very, very basic level. Prime contractors have different requirements than remote contractors in Tennessee, but that is our 2 buckets. Prime contractors, 90 days for the lien for priority, 1 year to perfect, or 90 days after the completion or the abandonment if you're dealing with priority. Remote contractors, we've got that extra step, notice of nonpayment. That notice of nonpayment is a rolling requirement that gets a little tricky along the way. Their requirements are a little bit different on timing. So that's where we are, that's where we've been. I'm glad to go back through any of that. Now, moving forward, the question is, when you're liening a property, what are you concerned about in terms of liability for an improper lien? Now, I'm going to give you a couple examples, some of which we haven't necessarily touched, some of which we have, and then we're going to talk to what is the liability and where is the redress period in there if you find yourself in a situation with an improper lien. So first, the 3 common examples that I'm just going to mention to you today is liening without notice of nonpayment or limited notice of nonpayment. This is a situation that I encounter more often than not with remote contractor liens when I have either the owner or the general contractor. And this is a situation where either the remote contractor didn't provide notice of nonpayments or provided a notice of nonpayment for maybe a small portion of their lien, but goes ahead and liens the property for the full amount of their claim. There is some case law in Tennessee that says, well, notice of nonpayment is fatal, which makes it an improper lien in that situation. We've also got the situation with multiple lots. I'm going to go into that in a minute because that gets a little confusing, and I've seen that on a number of residential development projects. I've also seen it on some projects where there are nearby but not adjacent projects that are being constructed together. The other one that I see is situations, material suppliers that haven't actually delivered material or holding them in a warehouse or holding them in some laydown yard, but going ahead and liening a property, or a situation where we've got designers who are wanting to lien for their design services when a project doesn't actually get constructed, both of which are no notice in Tennessee. So that's just an example, and again, we'll go through 2 of them here in a minute. The issues that you're going to see there, or the sort of checklist we're going to go down, is in Tennessee there is sort of a 30-day cure period, but if you don't cure within 30 days, you can be responsible for an improper lien, and with respect to certain of the improper liens. We've got an exaggerated lien statute, which says, hey, if you intentionally exaggerate, you're going to be on the hook. We've got slander of title, and then we've got a fourth one, which we'll also discuss a little bit, which isn't direct, but it is a motion to dismiss. So if you actually go to the process of recording your lien, filing your lawsuit to perfect, if your lawsuit to perfect gets dismissed, you can also be responsible for attorney's fees if you got an improper lien claim in there. So let's get going. I wanted to start you with one that we haven't talked about yet, but one that I think is worthy of a little bit of discussion. And this is a situation where you've got multiple lots, and it's a two-part test. And what this does is it says, okay, you are allowed, I'm going to start really with A, when you have two lots that are adjacent or continuous, and you're doing basically one project. This is a typical situation where somebody buys multiple parcels of property and puts a big project on multiple parcels rather than consolidating the parcels. What the lien law says is fine, no problem. You can put one lien down that covers all of those parcels. Now, we've then got a second situation, which is when it's an improvement or it's multiple improvements that's not to be used as a single improvement, or in a case where the lots don't meet the contiguous or adjacent parcels test. And what the lien law says there is what you'll see in orange, which is the liener shall apportion the lien. The case, and there's not a lot on this, there's a couple older cases under some of the outdated lien law and one under some of the newer lien law. The one under the newer lien law goes so far as to say in a situation where you have townhomes, the lienor was required to state exactly how much their lien was for each townhome or the smallest division of property. So if you've got $1 million lien and you know you put it on 10 townhomes, well, you've got to have some way to apportion it, meaning that you can't go in and put $1 million lien on one of the townhomes, or you can't go in and put $1 million lien on all 10 of the townhomes. Instead, you've got to divide that $1 million up and say 80 was here, 120 was here, or 100 was on all of them. You have to take some reasonable approach to that apportionment. So that is an issue that trips people up and gets us into improper and exaggerated liens. So I wanted to touch that today as we're talking. The other one that we commonly see in sort of this same improper lien situation is one in which material hasn't actually been delivered. And I say that from a material supplier side, there's only one exception to when you can lien without having delivered the materials, and that's the one you'll see on 4A3. That's specifically fabricated materials, and that even has some limitation in the sense of at some point, if you haven't delivered, there are arguments to be made that you have repossessed the material and thus don't have any lien rights. So if you haven't delivered, be wary of that. The other part of that is for designers, architects, engineers who may have lien rights. The common example I see here is where you get a lien or a threat of a lien from a designer when a project runs out of funding, goes south before it's actually constructed. I just wanted to remind everyone that for those lienors, being engineers, architects, they can only lien to the extent the improvement is actually made. So again, those are another section where we commonly see the improper and exaggerated liens. So what happens? What's the liability if you record an improper or exaggerated lien? And before I get there, I'm going to talk in a couple steps here and take you back a little bit. So in our lien law, we've got a couple steps. One, we've got to record the notice in the public register's office, then an attachment, then a lawsuit to perfect that attachment. Each of those steps require certification on the amount. So when you're looking at this, these first examples, each of those steps are going to potentially put you in a situation where you may have liability if you're a lienor who is pursuing an improper lien. The first of which is a statute or section of the statute directly in the lien law. It is in front of you right now. And I want to dissect that just a little bit. We've got forfeited, expired, or satisfied liens, okay? There's some very easy examples of forfeited, expired, and satisfied. There are arguments as to whether, for instance, we're talking about a notice of non-payment. Well, arguably, if the lienor has not satisfied the notice of non-payment requirements along the way, they have forfeited their lien rights. So this section of the statute may be applicable to them. We've also got the situation where we've got things like deemed abandonment, which require the liens to be filed within 90 days of the deemed abandonment. Well, if that doesn't happen, we've got an expired lien. So those two can be interpreted pretty wide to get this section, to give it some real teeth. The satisfied portion is pretty obvious in the sense that somebody pays you need to release your lien. The other part of it is if you go ahead and proceed with a lawsuit and ultimately fail, you need to release the lien. So the question is, okay, how does this work and what's my liability? And the answer there is this. The statute is sort of friendly in the sense that it gives the lienor 30 days to release their lien without liability. It's a situation when somebody decides not to do that, that the lienor, if they have a forfeited, expired, satisfied, or adjudged lien, that they are now exposed to all damages from the party sending the notice, and that also includes attorney's fees. And that is a really big hammer when you're talking about problems with forfeited, expired, or satisfied liens. Notice this is not one that says one with a disputed amount. And I say that from the standpoint of these are more your procedural problems with a lien, not necessarily the amount of the lien. So that's really what this statute deals with. Our next statute deals with the amount itself. And this is another section of the lien law. Again, it's on the screen for you. What I would put to your attention here is, yes, the liability is essentially the same as it was for our procedural statute that we just looked at. But this isn't just simply, hey, I am properly liened for $120,000 when the lien upon recounting should have been 105. This is somebody that goes in knowing, willfully and grossly exaggerating the amount. So this is a situation where someone comes in and liens, for instance, for a change order that has no real legitimate basis. Those type of issues can really expose somebody to this exaggerated lien. That said, from a lienor standpoint, be wary that for somebody to recover under this, there's got to be some real bad conduct that the court is not going to like, that they're going to agree is willful and grossly exaggerated. In general, that is a very high standard from a court to look at. Now, the other side of this is outside of the statute. You've got to worry about some old common law, which would be the slander or libel of title. I've quoted a case, one of the seminal cases here for you on what are the elements, what does a plaintiff have to prove before it can recover against a lienor. And what you find out is it's pretty similar to what is now statutory in the lien sections we just looked at. You're going to need malicious conduct. The courts have said malicious conduct. You need either reckless disregard of the property owner's rights or reckless disregard as to whether the statements are false. And the statements would be the recorded lien in the chain of title or the attachment to the property. So the law there is pretty similar. You will also see down in orange comes from one of the same cases. A good faith but erroneous claim of title does not constitute a cause of action for liable title. Again, a situation where you file a $120,000 lien, maybe it should have been 105 upon recount. That's not going to expose you, or should not expose you, to a slander or libel of title, absent some other factors. So there is some room for somebody that is going to record a lien to do so long as they're doing it in good faith. But there's really a line that can be crossed. One, if you don't comply with the procedural requirements of the statute, and two, if you get too aggressive in something that could get to a malicious or a reckless disregard, those type of phrases for a court is kind of that line that you cross that gets you in trouble as a lienor. Now, the other side of that I wanted to touch is this, which is a motion to dismiss. And this is in Tennessee. It doesn't exist in a lot of states. But this is a situation once somebody has filed a lawsuit. The lawsuit has to be a verified complaint in order to perfect the lien and the attachment of the property to the case. What Tennessee law, what the statute allows, is the very first thing after filing the complaint, a defendant, in this case likely an owner, can file what's called a motion to dismiss the complaint. Motions to dismiss are hard to obtain, but in the lien context, they're more prevalent because of the verified nature of the lien claim and the statutory requirements being strict. So in cases where you can get a motion to dismiss granted, the court shall award attorney's fees to the defendant. Okay, there is some leeway in there. There's some exceptions in other parts of the statute, but you've got to be aware of that if you're deciding to move forward into a lawsuit with a lien that is of questionable basis. So number one, you've got the statute. There's two sections of the statute which protects for procedurally flawed liens. You've got the section on your gross exaggeration, and you have this motion to dismiss, all of which can expose you to significant attorney's fees. And I will tell you, there are cases published out there dismissing lien claims on a motion to dismiss, even for the simple fact of not providing a notice of non-payment for a remote contractor. So generally, that's where we are with improper and exaggerated liens. I'm glad to answer any questions, but I think the 101 version is there's some latitude there to file a lien. There's typically a time period to correct it or release it if you have a procedurally flawed lien. But if you're going to go ahead and proceed with exaggerated liens or liens that are sort of in the gray area, you may expose yourself to liability, including all of the attorney's fees of the owner. So with that, I will open it up to any questions today.
So far, we do not have any questions. We'll wait just a few moments, and if anyone does have a question that they think of afterwards, certainly send us an email. You could see in the next screen all of our contact information. Bryan did a wonderful job. Thank you so very much. And again, if anyone has any questions, Bryan, I'm sure, is happy to answer them for you.
Yes. Thank you, everyone Hearing none, hope to see everyone back in about 4 weeks.
Absolutely. Have a sunny day, everyone. Thank you.